Mr. Graf?
Will the sponsor yield, please?
Will the sponsor yield?
Certainly, Al.
Sponsor yields.
Jeff, I got a couple questions on this bill. Now, under this bill, it's both men and women, right? It doesn't discriminate against either a man or a woman can bring if they're sentenced for a felony.
Given current law, I think it would be discriminatory
I can't hear you,
if we
Jeff.
establish it. I say, given current law, it would be discrimination if we establish a bill just for women or just for men.
Okay, I just wanted to clarify that. And the other thing, it also includes incarcerated persons, right?
Yes, it does. It has a resentencing component.
Yes. And some of the crime, now, when you look at this bill, they give you a criteria that the judge had. Now, they get a hearing. So even a sentenced prisoner can claim that he was either physically abused by a brother, a sister, a sibling, an uncle, an aunt, or somebody, anybody, and that's what made him commit this crime, or that's a mitigating factor, and he would get a hearing, correct?
The application would be reviewed by a judge before, and it could be denied. It doesn't automatically grant a hearing.
Well,
and that applicant has to prove he or she was a victim of domestic violence by providing proof through two pieces of evidence, one of which is either a court document or a police report.
And that would be a police report on domestic violence?
Yes.
Can they give just testimony from a relative or an affidavit from a relative?
That would happen if a hearing was granted, but obviously not before that. The judge will rule on the papers submitted.
And now on this, some of the crimes that we have here, they're violent felonies that we're talking about, correct?
Well, violent felonies, I believe, already have existing right for resentencing.
Well, under
already. This bill deals with crimes that are not in that category. Would you like to know what the category that allows certain convictions are not eligible for alternative sentencing? That is aggravated murder, first-degree murder, acts of terrorism, and any offense that requires registration as a sex offender.
Yes, but second-degree murder would be applicable under this, correct?
Yes, but it is currently eligible as it stands now.
And aggravated manslaughter would be another one, right?
Currently available now under existing law.
Well, no, we're rewriting this, aren't we? We're reducing the sentences. This is a mitigating factor to reduce the sentences.
No, I think you're a bit mistaken here. What we're doing is adding a series of crimes that are not now eligible to that eligible list. So we're not.
Well, on this bill, the District Attorney's Office or District Attorneys Association in the state of New York, you know they're opposing this legislation, correct?
Well, any time, Al, that we have ever allowed or expanded judicial discretion, the District Attorneys Association has objected because they like to be the final arbitrator of everything that's legal.
Okay. Well, according to the District Attorneys Association, did you read the opposition memo that they had?
No.
Okay. And basically what they're saying is that this is undoing parts of Jenner's law, right? It would undermine the legislative intent of Jenner's law to limit discretionary release of convicted violent offenders from state prison.
In our learned counsel's opinion, it retains Jenner's law and does not change any of those provisions.
All right, well, she may want to take another look. Now, according to the District Attorneys Association, right, is this true? The bill would also lower sentences further. For instance, the bill...
I didn't hear that last one, Al.
Okay.
I'm sorry.
This bill here right, according to the District Attorneys Association, right, would further reduce the minimum sentence to only 1 year for B violent felonies, such as manslaughter in the first degree, and other B felonies, including robbery, assault, burglary, and burglary in the first degree.
What it does, because that's how we started this conversation, is it gives the judge discretion over these instances that are covered in this law. So it doesn't give them that. It gives the judge discretion in the sentencing.
Okay. Well, what it actually does, though, isn't it true, Jeff, that it reduces, like a judge can sentence them from, say, 3 years to 5 years, and it reduces that down to 1 year.
It gives the judge discretion. You can't give discretion is discretion, Al. It's exactly what it's defined in the dictionary.
Okay. Now, the act continues. Now, what happens is the act contains protections to ensure appropriate use of this discretion. The judge can only grant an alternative sentence to a defendant if he or she finds that the defendant was, at the time of the offense, a victim of domestic violence, right? Subjected to substantial physical, I guess, assault. Can you tell us what substantial means?
Well, the judge will decide what is substantial. Obviously, the words are used to ensure that it is something that will alter someone's will.
Okay. And psychological abuse, what are we talking about here?
I think physical or psychological, both are judged whether or not they altered someone's will.
Okay.
I'm sure we recognize that people can be psychologically abused. In many cases, we have seen that in certain instances in the legal system.
Now, we also have that it has to be a significant contributing factor, correct?
Right.
All right. So in the case of, and this is one of the concerns raised by the District Attorneys Association, if I have an abuser, okay, who has severely beaten their loved one or severely beaten their child.
Excuse me, Al. Madam Speaker, can we have a little quiet in the back?
Members, can we have some order in the House?
He would be able to ask for a reduced sentence because he was abused as a child. Correct?
It has to be a significant contributing factor to the event that was raised.
Right. Well, if he's an abusive spouse or an abusive parent, right, wouldn't you agree that he could argue that because of the abuse that he suffered when he was 5, that's led him to be an abuser now?
But we're dealing with the instant offense. We're not dealing with some prior abuse that might have happened. This is about the case that is in front of the judge at the time.
Right. Well, we're talking about psychological impact, and it doesn't have to be simultaneous with the crime that they've committed. This could be abuse from the past. This could be something from the past, correct?
It has to be at the time of the event. It's judged at the moment that the act has taken place.
Can you point that out in the bill? I'm not.
All right. If you go to page 2, line 4A, at the time of the instant offense.
Where was that, Jeff?
Let
Sorry.
me try that again. Page 2, line 4A, at the time of the instant offense. The defendant was, and I can continue to read, but you can.
Okay. What I'm trying to get at, and what the DA's Association is getting at here also, is that, you know, you can be suffering at the time of the offense, right, from something that occurred a long time ago, psychological.
But Al, that's maybe a bill that you'll introduce, but it's not the bill that I introduce.
Okay,
So
well,
if you want to introduce that, I'd be happy to co-sponsor with you.
no, that's okay.
I thought so.
All right, can you talk about what you're talking about with community-based alternative programs?
And where are you finding that particular
This is in your sponsors memo.
in the sponsors memo?
Yes. 1, 2,
Oh, it
3,
could be
4.
probation. Is that what you mean?
Community-based alternative programs.
Right, which is, it could be probation. One judge might be able to, under the circumstances, given his discretion, given his ability to view that, grant probation to someone who is in front of them under this law.
Okay. And now, physical implications. Do you know how many cases you think this will, how many cases will arise
There
out of
were
this
some
legislation?
estimations made relative to the number of cases that this might be relevant to. Not a definitive listing of cases where it worked. I believe on the, let's say, we have estimated that there are less than 400 individuals who are currently incarcerated that this bill has potential effect. Less than 400, but not all 400. It is merely an estimation that they might be. They'll have to be judged because there'd be the application would be reviewed, the judge would decide no or yes. Additionally, using the figures that of people who were sentenced in 2014, they estimated that less than 500 would have been potentially eligible for domestic violence alternative sentencing. And I presume that's the individuals who were in front of the judge for new offenses in 2014.
Well,
but
there's
not a scientific, Al, not a scientific group of numbers, but a kind of a wide estimation of what might go on or who might be eligible.
So there's no time limit on this, though, right? A person could be incarcerated for, say, 10 years and then ask for this hearing.
Individuals who are in correctional facilities would have to have been there for at least 8 years before they would be eligible to apply for any provisions in this bill.
Right. And just going back so I'm clear on this, I mean, the standard of proof to show that you suffered from this, especially as time goes by, is it just police reports or court cases or court documents, or are we talking affidavits from family and friends to substantiate? Because, you know, over time, witnesses get lost and everything else.
Well, as I think we said in the beginning, one must be a court document or a police report. Must be a court document or a police report.
Right.
And the others may have other general information related to it. But we are counting on the judge to have to be anchored by documents that were already submitted by the police or by the court.
Well, already, I mean, a court document I could submit, right, an affidavit to the court attesting to whatever.
But
all
it
right?
would have to have, if they were incarcerated, it would have to have been in the trial that got them sentenced to, that they were sentencing for.
8 years ago.
Right.
Okay. And the cost of this, I think you say there's no cost, or they will save funds?
So here's the cost issue. So what is allowed is a public defender is allowed to assist someone if they get a hearing. And that estimated cost is about $4,400. If they continue to serve their sentence, every year we spend about $60,000 on every prisoner that we incarcerate. So the question is, one, whether or not you would spend $4,400 or have to spend $60,000.
Well, that's just attorney's fees, though, Jeff. I mean, wouldn't you agree that a lot of people that are sentenced to felonies are in state prisons?
Right.
So they would have to transport the person from the state prison to the local court because they wouldn't do it in the court where the prison was. They'd have to do it in the court of conviction, correct?
Only if they get a hearing, right, if they get a hearing. But a transport is not going to run up to $60,000 a year, I don't believe.
In your bill, on page 2, when you have a Class B felony that's applicable here, right, we give them how much they can sentence, the judge, how much he can sentence the person to, how much discretion he can have. And formally, for a Class B felony, it was 6 years to 25 years, correct? You can see the cross-out. Start at page
Must
39.
not exceed 25 years. On line
39, page
I got it.
So it was 6 years to 25 years for a B felony, correct?
Right.
And we're reducing it to the judge's discretion that he can sentence him to 1 year, but he can't exceed 5 years.
So the existing range is still available.
I can't be out of time. I just started.
I still have some power
Never
on
mind.
the prosecutor. And I certainly don't mean to use it against you. Absolutely not. I would never do that. So, I'm sorry. You can still, the judge could still give the 25 years based on his review of both the application, well, if the application fails, there's no question, but then the hearing that is conducted at which victims are permitted to speak and testify.
Right. You have a 3-part test, right, for the hearing. There's a 3-part test.
Right.
And as long as that person meets the 3-part test, the judge then has to go to the sentences recommendation for this.
He may. The judge must find. He's not mandated. He must find in his discretion that these items all rise to the level that a reconsideration is appropriate.
Okay. Well, if they're doing
And
a
it's
hearing...
not unsimilar to what I am sure district attorneys do when they decide to charge.
Yeah.
Right? Because they get a set of facts from the police and they investigate and then they decide, well, I think we'll go for this charge on that case because of that's what is recommended, that's what our office says. We're only saying that the judge, and we've said this before, is in the place and the position also to make that decision.
Okay, but the way I read this, Jeff, is if a person petitions the court to get a reduced sentence under this bill, and then there's a 3-part test, correct? Mm-hmm. And if that person proves the 3 parts, or the judge concludes that they've proven each part, each of the 3 parts, mm-hmm. then what happens is, on a B felony, right, after a hearing, he concluded that, yes, he satisfied part 1, satisfied part 2, satisfied part 3. And he ruled in his favor that, yes, you satisfied this test. Then he's limited to the reduced sentence guidelines.
No, he can give the original sentence. He's not limited. He's given discretion, not limited. Limited is if he could only do one thing. Discretion means he has the full range of options in front of him as a judge.
Okay.
Yeah. We're always in May. We never
All right,
will.
but we're reducing the sentence from 6 to 25 to 1 to 5 years, his option, right?
We have the option. You keep
I
saying
said that.
The judge has the option. Like you can sit down and not talk, or I can stand up and talk. The judge has the option to determine what the sentence will be based on this application.
Okay.
And the criminal history record, he'll look at everything. We trust him.
All right, let me ask you this. Let me try this. Here's a scenario.
Okay.
Okay? A police officer responds to a domestic dispute.
Mm-hmm.
Okay? He's standing next to the abuser, handcuffing him. Okay? Now, the person that was abused takes a gun, shoots towards the police officer and the abuser, kills the police officer. All right? That's manslaughter, aggravated manslaughter, B felony. That would fall under this, correct?
My learned counsel says no, because that would be murder one.
Well, not if it's not intentional. If they didn't intentionally try to shoot the police officer, okay, then it's manslaughter.
Right. Well, I guess we'd have some argument. I bet you the charging district attorney would not give him manslaughter.
Yeah, that's why we get paid the big dollars in a courtroom, because we can argue anything, any way.
Any kind of way you want. Absolutely. Yeah. You say so.
Now, the last thing, Jeff, and, the sponsor memo, right, becomes part of the law in that what my colleague pointed out, where he pointed out the language that said it could be, any of these things from when the person was younger, right, or was a child, and it affects them now. Mm-hmm. This sponsor memo can actually be, you would agree, this could actually be an exhibit in a court to prove legislative intent of what you intended to do with this legislation. Would you agree with that?
Al, that also part of that becomes the record of this debate. And so we've indicated exactly what I believe those statements are, not that they are to open up any past Whitcomb. So the legislative record probably overrides the sponsor's memo, if that were the case. But because I like you and I trust you and I really like your opinions, I'm going to look at the sponsor's menu.
I appreciate that.
After you vote for my bill.
Well, we all have to have goals in life, On the bill?
On the bill.
I mean, I think we can agree to disagree on this legislation. I think this legislation does some really dangerous things. I think it doesn't take in consideration the victims of these crimes. Some of these crimes are horrific in nature. And, for instance, on a B felony, we're going to go from a maximum sentence of 25 years, we're going to go down to 5 years. Okay? So I think a lot of times what we do is in plea bargains, we treat plea bargains as contracts. So we're going to go in and undo all of these contracts. And, you're looking at 8, 10 years down the road. This is going to be a great expense to the state. And not to mention, it's going to be a catastrophic scenario for victims of these crimes. So I would encourage my colleagues, and I think we need some redrafting of the memo that will become part of this bill. I would encourage my colleagues to vote no on this bill after considering the price that the victims will pay. Thank you.